Hello, everybody, and welcome back to the second panel. My name is Carys. I'm a member of faculty at Osgoode Law School in the intellectual property area, and it's really my pleasure to be here today for what has already been a fascinating discussion this morning. We hope to continue that now until lunchtime with this panel on AI and IP and commercialization issues, policy considerations. So I'm going to very quickly introduce our speakers. Their full bios are available on the website, so I won't go through them at length in the interest of time. And the speakers have agreed to each speak for no more than 15 minutes in the hope that we still have a little bit of time for discussion at the end of the panel, so that's what we're going to be aiming towards. So I'm going to introduce them in the order in which they're going to be speaking, which is not the order on the programme. So we're going to begin with Dov Greenbaum of the Meitar Institute for Legal Implications of Emerging Technologies at IDC Herzliya. Dov Greenbaum is a practicing IP attorney, an associate professor at the Department of Molecular Biophysics and Biochemistry at Yale University, and a non-resident fellow at Stanford University's Center for Law and Biosciences. Then we're going to be hearing from Carol Piovizan of McCarthy Tetro, LLP. She's a graduate of Osgoode Law School and also of the London School of Economics and Political Science, where she won many awards. And prior to going to law school, she was a policy advisor to the Minister of Foreign Affairs and a senior policy analyst who now specialises in artificial intelligence. Then we'll be hearing from Maya Medeiros of Norton Rose Fulbright LLP. Her practice focuses on creation, protection and management of intellectual property assets in Canada and around the world. She's also an adjunct faculty member at Osgoode Hall who teaches our IP and commercialization course. And then we'll hear from Aviv Gaon, who is a doctoral candidate at Osgoode Law School and, of course, one of the planning minds behind today's events. He's an IP Osgoode Fellow, an adjunct professor at IDC Herzliya, and specialises in intellectual property, law, technology, and artificial intelligence. And then we're going to wrap up the panel with Professor Alexandra George of the University of New South Wales in Sydney. She also had prior appointments at Queen Mary, University of London, the University of Wales, Swansea, and the University of Exeter, and she practices. Before that, she practiced as an intellectual property and media lawyer. She's the author of the book Constructing Intellectual Property with Cambridge University Press 2012, which I highly recommend. Okay, so enough from me. I'm going to pass it over to our first panelist with thanks.
All right, thank you very much. I want to give an initial disclaimer that the entire bio, I have to update it. That's all I'm saying. There's a need to update. So first of all, I wanted to thank IP Osgoode. I direct an institute in Israel, and we're looking forward to further collaborations. This was an amazing collaboration that we had an opportunity to do, and I hope to be able to do many more in the future. Okay, so AI, right? So I'm actually not going to talk about what we think to be AI. When we think of AI, at least in the West, we think of scary things like Frankenstein. In the East, they're a little less scared of AI and robotics. They think of more Astro Boy. He's a little more friendly than Frankenstein, although not the Lego Frankenstein. He's kind of friendly. And what is this fear? Well, we have Stephen Hawking saying the development of full artificial intelligence could spell the end of the human race. Bill Gates, I don't understand why some people are not concerned. A little understated, but I think he's concerned about jobs. Elon Musk, our greatest existential threat. That's pretty intense. Now I'm blanking on her name. Theresa May. She just said this at Davos last week. AI poses one of the great, obviously she's dressed for Davos. AI poses one of the greatest tests of leadership for our time. And most recently, coming from the East now, Jack Ma said artificial intelligence is a big threat to humans. AI and robots are going to kill a lot of jobs because in the future, these things will be done by machines. I'm not going to talk about this area of AI, and I'm actually going to quickly segue into a little bit about my institute because I'm really keen on developing interactions like this with Osgoode, with other groups here in Canada. So our goal is to examine broadly the ethical, the legal, the social implications of new and emerging technologies, both in high tech and in biotech, particularly disruptive technologies. I run a program where we have a number of students. I have 20 or so students per year. This is our third year, and we do projects like this AI project with stakeholders in the area. We've worked with IBM, with the Ministry of Transportation in Israel, Deloitte, Stanford University, Teva, Fifth Dimension, which is a deep learning company, Wave, which is a blockchain company. Bitcoin is going down, down, down. 3D printing company, and this year working with the NIH, Intel, autonomous boats as opposed to autonomous vehicles, food tech, grinding up flies and making them into food, not as gross as you sound, and Bitsala, which is, we're looking at urban design in the Internet of Things. We also do programs like this. So this is mostly in Hebrew, but we do programs on AI, on VR, AR, fintech, IoT, robotics, smart mobility, and blockchain, also in Hebrew. But let's get back to AI. Enough of the digression. When we think of AI and IP, we think about this monkey. I think he's a monkey. Is everyone familiar with this monkey? This monkey took a selfie, like our kids take selfies, or like we take selfies. And it was argued that the monkey should have intellectual property rights for his image. Similarly, you would argue a machine, like a monkey, may be an author, a copyright author. In patent law, we can also argue the similar sort of thing. Can a machine be an inventor? I don't know. I'm a U.S. IP attorney by trade. I'm not sure how important it is, the inventorship in Canada, but in the U.S., inventorship is a huge issue. And do you have to disclose that your inventor is a machine, an AI? Again, these are not the issues I'm going to get into. I'm not going to get into the issues of authorship, which would be a really interesting issue in, I don't know, hopefully someone in the panel is going to do this. Maybe not. But this is not what I'm going to do. I'm going to go look at a subset of AI. So AI is broadly an umbrella that includes machine learning and deep learning and other areas of learning by machine. AI, we've all been talking about AI, and it's a question like, what is AI? So AI, everyone remember Clippy from Microsoft Word? We all deleted it as soon as it got on. Clippy was AI. Uber, when Uber decides when to surge price, they're using AI. When Netflix decides what video to say, hey, you watched, I don't know, Terminator. Maybe you want to watch another AI movie. That's also AI. When you run on autopilot, not like Leslie Nielsen, late great Leslie Nielsen, that's also AI. When you take a picture of your check, that's natural language processing. That's an AI that's reading your check and deciding what actually it says. Alexa and Google Home, that's also AI. All these different things are all AI. By the way, Alexa thinks that the Eagles are going to win. Google Home thinks that the Patriots are going to win. We'll see who's right. Alexa always goes for the underdog. And even Levi's. Levi's is using AI to decide, what pants fit me best. That's AI in a nutshell. Machine learning, another area of AI, also I'm not going to go into. But for the crowd, can everyone tell me what's that thing on the left? Say it out loud. On the left. Oh, my left. You're right. It's a kitten, right? What's the thing on the right? A cute puppy. Can anyone look at this image and tell me, by looking at this image, how can we build a set of rules that allows us to always say the thing on your right is a cat and the thing on your left is a puppy? Can anyone venture one or two rules? Yeah. Okay, but some dogs probably also have pointy ears. Okay. The length of the snout. Length of the snout, but some, it changes, right? Whiskers as well. There isn't an easy way to do it. Yet, anyone here have a 2-year-old? Something near a 2-year-old? You ask your 2-year-old, they know intuitively the difference. We want to build machines that can decide the difference. And that's what machine learning is. Some of this we talked about in the roundtable, which is referenced earlier. This is supervised learning and unsupervised learning, where you get a list and you classify it. So based on that, that's what a list, you'd be able to tell whether or not that's a chihuahua or a muffin, right? We can tell, and we talked also about, Ian talked about pattern matching, and this is what machine learning does. It can tell you, to some degree of certainty, even we can't all do it, what's a chihuahua and what's a muffin. Again, not what I'm talking about. I want to talk about what I think is the most important thing of artificial intelligence, and that's what we feed artificial intelligence. It's big data. And we have a technical term for this in computer science. It's garbage in, garbage out. Whatever you feed the AI, that's what's going to, it's going to impact what it outputs. And if you feed it bad big data, it's going to output bad analytics. So I'm going to talk about some of the IP issues in big data. So now we're getting to what I'm talking about. So what is big data? Big data is different than other data. How so? 3 ways, 4 ways, 5 ways, depending on what website you go to, depending on what company you talk to. Basically, this is a nice IBM website that lists volume. You go to any big data site and they'll all tell you that within the last 2 years we've created more data than we have in the last 200 years. And every 2 years we say the next thing. So we're constantly creating a deluge of data. So just the size of the data, it's enormous. The velocity of the data, it just comes at us like crazy. The veracity of the data, whether or not we can trust some of the data is different. We all know that there are some people that tweet things that are trustable, and there are some people that tweet things that aren't trustable. I'm not going to go into any specifics. I'm not going to point anyone out, but Aviv, I'm looking at you. And the variety of data. We get a lot of data in terms of, we get images, we get text, we get sound, we get video. All this is what's combined into big data. And even though this is a good definition of big data, there are lots of sectors that say we have big data, even though they don't. So what's a great example? Law. Law claims to use big data, but if you look at it, it's nowhere near the amount of data that we would have in other fields, high energy physics or bioinformatics or something like that. But well, it's also a buzzword, and I think it's important to define it. So why is big data so big? Well, everyone remember the floppy disks, right? We don't have those anymore. We're down to the cloud computing. The amount of this thing that they're putting into a Pan Am plane, we don't have those either. But that's a 5 megabyte hard drive that they're loading into a Pan Am plane over there. So the amount of data is increasing because storage is dirt cheap and it's really small. We can miniaturize storage into a USB stick or smaller. Also, the amount of computational power allows us to have a lot more big data. So that on the right, my right, also your right now, is the Apollo rocket, right? If you take out your phone has more computational power, and this is something that everyone says, right? More computational power sitting in my hand than what got us to the moon. Obviously, it's a little disingenuous because to get to the moon, you really don't need a lot of computational power. You just have to compute a couple things. My phone has to do a lot more than the Apollo rocket. So those are 2 reasons, among many, why we have so much big data. The third reason why we have so much big data is because of you. You guys. You guys are creating our big data. This is an internet minute in 2012. This is how much data you were creating in 2012. I don't know, 30 hours of video uploaded every minute to YouTube. That's a joke today, right? 320 new Twitter accounts every minute. All this is all data. What am I, 5 minutes already? Oh man. 2017, even worse. This is how much data you are creating now. 40,000 hours listened on Spotify every minute. All that data is being streamed. 46,200 posts uploaded on Instagram. Half of those are my teenage daughter. 4.1 million videos viewed on YouTube. That's my 8-year-old son. But you can get the idea of how much information we are creating. And all that is big data, and all that is being mined by the AI algorithms. And all that begs the question, first of all, keep in mind that we're giving it away, right? As they say, if something online is free, you're not the customer, you're the product. We are creating this data to give it away. Who are we giving it away to? To Google, to Facebook, to Twitter, to, I don't know, Instagram, to everyone. And they're collecting this data. And now we get to the IP issues in the last 3 minutes. We're not even, well, I'll skip ahead. Okay. Is there ownership in this data? Who owns the raw data that you guys are spitting out every second? Are there protection regimes that adequately protect the databases that are holding this data? Who owns the tools that aggregate and analyze this data? And how do you protect them using IP? Who owns the resulting analysis? So the secondary sort of data, and who owns the resulting insight, which is a step removed from the analysis. So basically, the easy ones are the first ones are easy. Who owns the raw data? You can't protect it with copyright law. Feist basically said that you can't protect, at least in the US, again, I'm a US attorney, you can't protect raw data. Not really true. You really can. But you also can't protect databases for the most part. So raw data is not copyrightable. Databases are not protected by copyright to some degree. We have, at least in the US, do we have something similar in Canada? We have the Digital Millennium Copyright Act that basically says, I want to protect something that's not copyrightable. I just put it up on the internet. I throw up some digital rights management protection. Poof, it's now protected under copyright law. So actually, we can protect databases and the underlying data if we throw it up on a database online with some sort of digital rights management. And again, in the efforts of time. Okay, so who owns the resulting analysis? Who owns the resulting insights? Well, if you think about copyright law, we have copyright attorneys here, right? Yeah? All right. Is it a derivative work? If you take the data and now you modify it and you run it through an AI, is that a derivative work? I don't know. Is it transformative? Does it fall under fair use? Fair use allows for some sense of transformative use. Once the raw data, you know, your images look nothing like the stuff that they're selling to the third parties that decide that you deserve to see this ad for a new canoe, right? So IP, in terms of IP protection, copyright officially doesn't, but the DMCA allows it. An alternative way to protect your data, the data that you've created and are giving away for free right now, everyone who's on their phone, you're giving away your data for free, it's trade secret. Right? Trade secret is something that's generally known in, is not generally known in the industry. The owner has made appropriate efforts to keep secret and confers a competitive advantage to being kept secret. So once you give all your data to Google, to Facebook, to Twitter, to Spotify, all that data, if they just say, we're just going to protect it really well, that's trade secret law. Trade secret law protects it. Typically protects formulas, devices, software, compilations, designs, processes, customer lists, but it can also protect all the big data that you guys are giving away for free. And there are protection measures that if you want to protect big data with trade secret, these are how you would do it. You could also protect it with cybersecurity law, which really isn't IP law, but is relevant because cybersecurity basically says that if I put something up on a database online and I password protect it, and I use, anyone see Spaceballs 1, 2, 3, 4, 5, I write that as my password and someone guesses it, or Kerr, no relation to Ian Kerr, who I've been told is no relation, that is a prohibited unauthorized access and you're in violation of a criminal statute in the United States. In terms of protecting the algorithms that are analyzing the AI, so in that probably falls under software, and all the IP attorneys here know that software is really hard to protect now. I mean, there are ways to do it, but there are protecting them under intellectual property requires, what was the term we used? Finessing. So maybe IP isn't the way to protect data. Maybe we should make it public versus proprietary. Maybe we should make it open source as opposed to closed. Some things that the EU is thinking about. Or, right, data just wants to be free. Notwithstanding the privacy issues, and again, I'm out of time. So maybe the Japanese are really thinking about how to change IP law to allow to protect, to create some sort of new way to protect the data. And maybe either we go that way, where we think about protecting data with real IP, the data, again, that all you people that are on your phones are now giving away for free, or maybe the right way to do it is to make it just open source, and the real money for all these companies is going to be in the analytics. And a great sort of, and I'll end with this, genomic data was given a cost 15 years ago, it cost $3 billion to sequence a human genome. Today it costs $1,000. But when it cost $3 billion to sequence a human genome, the company that did it, Celera Genomics, gave it away for free. even though it cost them $3 billion, or they cost the US government $3 billion. Solera did it for cheaper, but it's still a lot of money. They gave it away for free. Why? Because the data in and of itself isn't that important. It's not that useful. It's the analytics, and they charged a fortune for the analytics, even though they went bankrupt. So in the end, maybe we don't even need to protect the data with IP. Maybe we should look towards just protecting the analytics, giving the data away for free for everyone to use and to analyze. And I'm going to end with that because I'm out of time. All right, so thank you very much. All right.
So I'm going to start by making full disclosure. I give away my data all the time. I do it particularly at dinner time with my 2 kids when I play Peppa Pig, because it is the only way to get them to eat. I do it voluntarily, and I don't mind. Thank you, first of all, to IP Osgoode, to Professor D'Agostino, to her team, to Professor Carys, Craig, for inviting me to speak here today. And thank you also to my esteemed co-panelists. I think this conference is very important because Canada is really at the precipice, as much of the world, of trying to define what its policy framework is going to look like in the context of AI. And discussions like this are a starting place to get academic, government, enterprise together to share ideas and views. The focus of my presentation is going to explore in particular how AI is stretching some of our policy and legal frameworks. I'm going to start very briefly by talking about some of the facts in the global race for innovation, and I'll just touch on that because I know it's otherwise been discussed. I'll then move to highlight some of the unique features that are requiring some pretty thoughtful debate about how AI is stretching our current framework. I'll situate that in copyright law just to raise some questions. And then I'll close by proposing a very basic general legal framework for how to analyze AI as a starting point. So let's start with some of the facts. It's now trite that we are in a global race for innovation in the field of AI. We know that countries are jostling for the first place as the leading nations in AI innovation. And there is very good social and economic reason for this. Where AI is expected to contribute upwards of $40 billion to the global economy by 2020, it's also expected to disrupt almost every industry and sector. This year alone, the use of AI in business is expected to grow by 62%, which is a rapidly increasing adoption of the technology into the mass market. Now, policy and law are always a step behind innovation, and that's almost by design. Both policy and law are often used as mechanisms to identify a problem that exists and to address that problem. But with the current pace of innovation, it's happening so quickly, and it is on such a transformative nature that policymakers are being forced to anticipate issues that don't necessarily exist here and now, as are lawyers, while also addressing issues that do exist. And businesses face the same struggle. The struggle for businesses is to innovate, to be seen as innovating, and then to figure out what their internal risk management strategies are going to look like as they deploy and as they prepare and deploy these technologies into the mass market. What is it that's so transformative about AI? And why are we so excited and concerned? You heard some of this morning. At the heart of it, I think the issue is that AI is increasingly human-like, but without being human. And this causes some real complications when considering the legal and policy framework, which is quite human-centric. So why do I say that AI is human-like? This statement used to be more controversial. It is increasingly less controversial. And it certainly engages a profound philosophical debate. But artificial intelligence is really the intelligence to do something that is otherwise required by humans. It is the ability to learn, adapt, reflect, increasingly show empathy. Those are forms of intelligence. I recently listened to an hour-long podcast on conceptualizing the notion of intelligence, which is a concept I used to take for granted up until then. But let me present to you a definition I recently read. It's from a 2011 article by Colin Davies in the Computer Law and Security Review, in which he wrote, "Intelligence is the ability to adapt one's behavior to fit new circumstances." So this would encompass a number of separate components: the ability to learn, to reason, of problem solving, perception, and language. Human traits. Now let me present to you the example coming out of the University of Osaka. As a mother to 2 kids, I found this quite remarkable, that they are creating a child robot, and the purpose of the child robot is to learn social skills, it is studying facial expressions, and increasingly it is predicting whether mom is happy or sad. And the projection into the future is that there will be an artificial brain by next year. Very human-like qualities. Taking information that is not only quantitative, but that is of an emotional nature, is starting to really push the boundaries of how we define and understand and conceptualize humans. Now let's turn for a moment specifically to the question of IP. The World IP Organization defines IP as products of the mind, inventions, literary and artistic works, any symbols, names, images, and designs used in commerce. And a first principle of IP protection is that the creator or the inventor should be recognized and rewarded for his or her creation or invention, that innovation should be rewarded. A starting principle, a founding principle in the protection is that innovation will be incentivized through recognition and reward. Well, not necessarily, right? If you have a system that is inventing and that is creating, is that starting principle, that first principle, applicable? Is there any evidence to suggest that AI will be incentivized to create because of reward? And if not, then are some of our first principles in IP law being challenged because of the nature of AI? Second, and this was touched upon by my friend just before, to protect AI under copyright, for example, our systems require some degree of nexus between a human involvement and a product. And it varies depending on jurisdiction, but there is some nexus between the human mind and the creation. But again, deep learning systems are really starting to challenge some of that. It's putting a strain on the current policy framework, even where minimal human intervention is involved. So as my friend asked you before, who is the owner? Increasingly, AI is not seen as a tool, it is seen as a creator. It is seen as an inventor. It is taking disparate parts of information, whether the information is tactile, whether it's written, whether it's auditory. It's combining that information in an analysis, and it is doing something with it. So is it creating music? Is it the next Rembrandt? Has anyone seen the AI-created Rembrandt? It's beautiful. What really got me thinking, though, is why do I care so much about Rembrandt, then? It's because Rembrandt could do something I can't do, but a machine isn't me. I don't identify with it. So if the machine can do something I can't do, will I value it in the same way? Not now, but maybe over time. I told you that I would want to end by presenting a basic conceptual model, or I think that's too strong, a basic legal analytical framework for starting to think about AI, because this is something that I do quite frequently. I don't know if you can tell. And so I'll just take a moment to walk you through, because I think it has very, very practical business implications. So as we sort of come down from the sky and start thinking practically about, well, if you're talking about these challenging notions of what does it mean to be human, or what is deep learning, and how does that impact on some of our founding principles of some aspects of law that protect innovation, let me offer you this. I propose to you to think about AI in three regards when it comes to trying to put a circle around it from a legal perspective. The first is think about the nature of the system. And by that, what I'm trying to do is help situate, at least as I think in my mind, to help situate what kind of situation, what kind of system is this? Now, as a litigator, that is what I do, because when I think about, you know, if I had to challenge or if I were defending this, how would I conceptualize it to the court? And what would matter to me in terms of, is this a product liability issue? Is this a contract issue? Is this a tort issue? How do I conceptualize it? And what are the different implications? So what would be more favorable to one client instead of another? Which is why I say start with the nature. Think about the nature of the system. Is this a wearable? You know, is this a product liability issue? Is this a wearable? Is this a software, a fundamental software issue? Then turn to its purpose. What is the purpose of this system? Is it a tool? The example I often give, is this a truck to a truck driver? Is it an agent? And I'll pause there for a moment, that I did read one article in preparation for today that suggested that the way to get around questions of humans and human involvement in copyright law, particularly in the US context, is to frame the AI as an employee. And that way you don't fundamentally have to reshift everything within copyright law, but there's already some exception for it contained within. But that also raises some pretty other interesting issues about, could vicarious liability ever extend because an AI system did something that's totally wrong? Don't close your mind to the possibility that it could be one day an autonomous agent. The AI itself will attract liability. The EU was exploring this, though I believe they've abandoned it, but Estonia has come out, not surprisingly, they often are ahead of the game on some of these issues. Estonia has come out seriously considering whether to extend personality to an AI system the way we do here to corporations. And then finally, consider the issue of control. Who controls the system? Is it the programmer? Is it a third party? Is it the end user? And again, when we think about copyright law in that respect, the question of ownership, is it the programmer who created this system, even though the programmer, him or herself, may not have had any idea the system would create something so beautiful or so unique? Or is it the end user who manipulated the program? And I suggest to you that that matters not only in the context of IP law, but throughout as we consider the implications of AI in law. And once again, don't close your mind to the possibility that one day it constitutes as a fully autonomous agent and thus attracts its own liability, because it is its own controlling mind. These are obviously very exciting times, and there are a lot of philosophical debates. And in the race for innovation, what is happening is a passing of a baton between academics, government, and enterprise as we all seek to figure out who bears control and who should lead the discussion about AI. And this is not at all a criticism. This is just to show the extent to which this is a complicated issue that does require very thoughtful and consultative debate. Thank you.
Hi, everybody. My name is Medeiros. I'm a partner in the IP group at Norton Rose. I'm also a patent agent and a trademark agent in the US and Canada. So what I do pretty much every day is help companies develop an IP strategy and protect their assets, as well as looking at commercialization path. Before going to law school, I studied computer science and math with a specialty and a focus on artificial intelligence. That was many, many years ago. So it's nice to see, and it's actually very exciting to see, the accelerated pace that artificial intelligence is taking today. And I think, as Dov mentioned, it's a combination of three factors. We have an increase in computing power, and also with the cloud, an accessibility to this computing power. We also have better algorithms. We're seeing better algorithms with the advancements of deep learning and reinforcement learning and other types of methodologies. And as well, we're seeing a lot of data, and data being stored much cheaper. So it's nice to see those three come together, and it's an exciting time, definitely, for artificial intelligence. So to give you an overview of my talk today, I'm just going to talk about the existing framework for IP protection as it pertains to AI innovation, as well as the new questions that it raises. And I'll also look at collaboration and models around collaboration to foster this innovation, and then get into a little bit of the ethical and legal considerations and how it pushes on intellectual property. So looking at intellectual property, as Carol mentioned, it's supposed to foster and protect and encourage innovation and creativity. And so we need to look at IP protection for Canadian AI innovation to build our AI economy and that foundation. When you look at intellectual property, there are various mechanisms that you can use that are complex and overlapping to protect AI innovation. We can look at copyright, as we talked about already, and there are some shortcomings, but I just want to highlight that copyright does protect computer code as a literary work, which is actually the technology product itself. So that's a very important asset for an AI innovator, and so that is the technology product itself. And so there is a computer code protection, as well as there's application programming interfaces, so a series of calls or methods, and there's actually a creativity that is put into that. And you see in the US that there actually has been some copyright protection afforded to that. As well, compilations of data, and that varies, and there definitely are limitations, and we'll see that kind of teased out as Professor Craig and I were speaking about yesterday. And then layering contractual obligations, which I'll touch on a little bit when we're looking at commercialization models. And so there is existing copyright protection for AI, and also the graphic elements of AI, which I think the visualizations are so compelling, which leads me to another type of protection, designs, which again exists. In Canada, it's industrial design. In Europe, it's community design. In the US, it's a design patent. And that protects the aesthetic look of a finished article, and that does attach to user interfaces. And I think what I really like about some of the AI models that we're seeing is taking this raw data, there's transformations of that data, and then providing very compelling visualizations to enable experts or other decision makers to extract relevant information and make some decision based on that, whether it's in the healthcare context, the financial context, or other industry use cases like energy, for example. So we definitely see design protection attaching to those form factors and that aesthetic. We also see trademarks as well, because given the importance of having a very accurate algorithm and that reliability, we'll see brands become, again, increasingly relevant for all types of innovation, but in particular, artificial intelligence. One thing we think about is, what if you're providing sort of the black box of the underlying code, and you could take more of like an Intel approach, where they put their sticker on computers. So make sure to consider co-branding arrangements and the like, to make sure you get your brand out there into the consumer's mind, because again, from a trademark perspective, use and the consumer perspective is what drives your rights and the scope of those rights. We also want to look at patents, and they protect inventions generally, and that could be a process or a machine and improvements of those. And people often say, patents don't protect software, which I think in a very general sense, maybe not, but definitely patents are being granted for machine learning and other AI innovations. There was a report, IFI issues a report every year about US patent publications and trends, and they have one interesting thing about 9 different trends, and machine learning was number 3, and it grew at a compound rate of 34% from 2013 to 2017, and that doesn't include use cases. So autonomous vehicles was also, I think, number 6 as well, or medical devices and the like. So definitely definitely patents are being pursued in this domain and are being granted. I think as well, and part of that report, IBM was again a trailblazer or the leader, and I think they broke a record this year of 9,000 patent publications. Again, not specific to artificial intelligence, but I think we're all very familiar with the IBM Watson program and how much innovation they're doing in that space. So I definitely imagine a chunk of that 9,000 relate to artificial intelligence. So the landscape is already becoming dense for patents, and so I think we just have to keep watching this space, and that is really going to be important for innovators to be able to navigate that. You have to look at patent eligibility, and as Dov mentioned, there was a case relating to fintech innovation and somebody trying to patent a long-standing economic principle, and the Supreme Court in the US said, no, you cannot do that. And in that wake, it did put a lot of uncertainty into the patent eligibility of software. But the US Patent and Trademark Office is sort of banding together and trying to grapple with these questions, and they are granting patents relating to software all the time. There is a panel at play, and they do consult a lot with industry, but they are granting patents in this space. An example it relates to lip synchronizations in the animation space. And so the court said, after looking at this in detail, they've said, yes, if there's very specific rules that enable a computer to do something that it otherwise couldn't, that is patentable subject matter. And in that case, it was a better way to make a mouth move. And then it was actually a very manual process before. And now a computer was able to make those lip sync movements on its own. And so the court said, yes, this is definitely patentable subject matter. Again, it's moving all the time. We watch the court decisions around 101 or patentable subject matter in the US, as well as looking at Canada and Europe. And I think every week we have our articling students look and watch that. They have a new case that they report to us. And so it's definitely an uncertain time, and there's no clear lines, but there is patents in this space, definitely. As well as Dov mentioned, trade secrets and confidential information are a huge asset for companies because it protects their back-end code or their secret sauce. And I'll touch on a little bit of tension between ethics and this notion of transparency in a little bit as well to get into that. But that back-end code is protected by trade secrets and confidential information, but also copyright, because there's no requirement to publish your work to get copyright protection. We'll get into a little bit about the difficulties of actually being able to detect an infringer, because one thing about patent law, and even with trade secrets, is how do you know when somebody has your stuff or is infringing your patent if you can't even actually figure out what's going on under the hood? So there are definitely a detectability issue relating to infringement and to be able to enforce your patents, but there are patents and activity in this space all the time. I think given this view, this complexity and the dense landscape around IP for AI, it's going to be even more important for companies to be very savvy on IP to navigate their freedom to operate. And I think that's ultimately a really important and a huge strategy for IP for innovators, is to be able to actually just practice their business and practice their technology. And so that's definitely a reason why you should consider developing a strong IP strategy for that. There are new issues being posed by AI innovation. And as I have this picture of the monkey selfie right here, but just to go back, I mean, a lot of what you're looking for when you're looking at IP issues, and as Carol mentioned, from a litigator perspective, what often becomes very important issues from a copyright and patent perspective is ownership, inventorship, and authorship, because authorship and inventorship will lead to ownership, and you need to figure all of that out when you're looking at the chain of title. And so when you have machine-generated IP, well, who is that author? Is this work even an artistic work? Is there creativity if a machine is generating that? Is this protectable by copyright? And does this protection actually extend to machines? And who is the owner ultimately of this? And so how we're helping companies navigate these issues is bringing a human into the loop as much as possible to help create that link between a human creator and the work. And so if the AI can come up with a solution on its own, then that might be a more efficient mechanism. But if the AI is processing, you say 1,000 or 1,000,000 different options and presenting 20 to a human user, and then that human user selects 1 or 2 or 3 of those options, then perhaps that might help strengthen the claim to ownership in that actual eventual art. So bringing a human into the loop is something that we're encouraging a lot, both from a liability standpoint, but also from this IP notion. And similarly in the patent space, if a machine is tinkering and comes up with say an automated cooling process on its own, we're finding known methods or an initial more generic process. Well, who is the inventor of that? One example I want to talk about, I'll touch quickly on this, but we already mentioned this. This was posted to Wikipedia, and essentially Wikipedia said there's no copyright in this. This is in the public domain. And the photographer challenged that notion and said, actually, I would like to claim some copyright in this. And PETA came in and stepped forward for the monkey. And ultimately, they did say that there was no copyright attached to this. But I think as we see more and more, maybe if the human was involved in helping frame the photo or somehow involved a little bit more in that process, we might see a different result. I find this to be a very interesting example. This is an AI tool, Ava, I think I'm pronouncing that right, out of Germany. And it actually composes its own music. And it released a CD, Genesis. It's actually recognized as an author, or sorry, as a composer. And it actually has copyright to its name. This hasn't been challenged yet in court, whether these registrations are valid or not, but it'll be very interesting to see how that evolves. But AI is creating music, AI is creating art, AI is writing, so we'll watch and continue to see how policy adapts to see how the protection will be granted. One other notion I want to talk about is collaborations, and I think collaboration is so important for IP and innovation more generally, but actually it's very difficult to develop a system and then just work on your own. You're always going to be engaging third parties and working together. And one thing we're seeing, a trend in industry we're seeing, is the changing notion of license agreements or just collaboration agreements when you're looking at AI technology. It is different than regular software, because it updates over time. The software updates and changes over time. There's also a huge importance on data. And sometimes I actually talk to some AI companies and they say, actually, the classifiers are what we really care about. We don't care about the data. But some companies say, we really do care about the data. So if you have a very unique data set and that can't be readily available or obtained somewhere else over open channels, then perhaps that data will be very important as well. We also see experts having to be involved as well to help train these systems or refine the output and tinkering with them to tune the system. And so this is a little bit different than traditional software. And so we need to take a new approach when we're looking to create an agreement or a framework, because it's very important for collaboration to have clear expectations set from the get-go. And that's why I really do think that an agreement process is great for that. Whether we hope that agreement is never enforced, hopefully Carol never has to touch that, but well, but I think that it's important to have that transparent discussion about expectations and who owns what to avoid all of that in the first place. And so when you're looking at licensing or collaborating in an AI framework, you need to look at different perspectives, whether you're the AI provider or the data provider. And as I mentioned, how unique that data set is. We see that data providers generally have the ability to grant access to their own data, and then the ability to contain or control that access to the data. Whether that technically is possible or not remains to be seen, because if your data's out, how are you going to be able to figure out if somebody else is using it? But you do generally have an ownership right or an ability to grant access and then to take that back if the license agreement or the collaboration, it comes to an end. And so we're seeing that, and generally there's no pushback in that space, particularly around industries like medical data, where there's no claim to that data in the first place. The companies just want to get access to it so that they can tune their classifier for that context. What we do see, though, is from a data provider perspective, is you might have a limited benefit if you're just giving your data away, besides the compensation aspect to that benefit, because you don't actually get access to the AI tools necessarily unless you have this very unique data set. And in that instance, sometimes we're seeing AI providers being okay with having a shared model of ownership or somehow enabling that data provider to benefit in how they're exploiting or commercializing the innovation. So that's something that you might be able to have some wiggle room or some negotiation room around that if you have that. We also see that sometimes data is just in a really bad state. And so if you're providing your data as a data provider and you don't want to invest a lot of money into cleaning it up because you might not get the benefit of this classifier at the end or this AI model at the end, then what you can potentially ask for is a pre-processed version of that data. And so you actually get a better version of the data that you can use internally or interoperate with other data sets as well. So that sometimes is a way you can get some additional rights or additional value from the data that you might otherwise have, without you having to do anything, which is pretty nice. Well, besides give up your data for a little bit. One other thing we are seeing is that AI providers should have clear data handling policies in place, because often they're given access rights to data, and it's very difficult to be able to slice and dice the data after the fact if one of those agreements were to terminate, those access permission agreements were to terminate. So clear data handling policies are definitely recommended and encouraged, and you can use technology measures to enable this. So you have data lineage, for example, so you can identify the source of your data should you need to carve that data set out and remove it from the overarching data set that you have to build your AI algorithm on. So that's something that we are seeing more and more as a requirement in this. We also see that AI providers are trying to own or have control of the aggregation of all of the data and from different sources. And so that would often be transformations of their data. And again, whether they actually have ownership of this, who owns this, is there actual IP protection to this data in a transformed way, it's unclear, but it's always better to put it in the contract at this point. At least you could turn to that, and we'll see, and then see how the law evolves after it's been tested a little bit more. So these are some sort of high-level considerations that we see. We also are seeing different compensation models evolving. So we often avoid co-ownership. It's just very messy to have two owners own an AI tool. But what we do also see is sort of a revenue share. So if you are a data provider and you have a unique data set, you could ask for sort of a kickback of any commercialization revenue from the ultimate refined AI tool that comes out from that. And what we also do see is sometimes a sub-license is being granted as well. So that data provider, if they have a sufficient unique or valuable data set, could actually grant a sub-license ability to somebody else. And then again, there's a revenue share that enables a flow of compensation to both parties. We also do sometimes see non-exclusive other arrangements, so they can go ahead and license the agreement, or license the technology themselves as well. So different compensation models are evolving. And one final point, and I'll say, is we do see some tension between ethics and IP, in the sense that if trade secrets are protecting the underlying algorithm, how do you balance that with transparency? And I really like Deidre's point earlier, looking at it from a social transparency perspective, as opposed to opening the code, looking at explaining the functions a little bit more from a high-level point of view. And I think that could help resolve those tensions. Thank you very much.
See if it's all right. Okay, thank you, Professor Craig, for the kind introduction. I have to say that I'm very excited to be here. It is a great pleasure to share parts of my research with you, and I look forward to your comments. And as Pina always says, the discussion continues. So I hope that we'll have a chance to discuss some of my ideas here later on. So the purpose of my presentation is twofold. First, I present very briefly the recent developments in artificial intelligence technology, establishing where we are today. In the second part, I offer suggestions for possible changes in the legal framework, arguing, this is basically my research, arguing for AI rights, AI IP rights. Let me start very briefly to introduce a very obscure creation, sort of Siri, Samantha. So for the purpose of this presentation, Samantha is an artificial intelligence program, and she clearly possesses unique capabilities different from any other computer. And for example, Samantha is from the movie Her. Samantha can evolve and use her own choices to choose a name for herself. She actually can create music and create art. The question that I pose here, and I ask you this question, is who owns Samantha's music or inventions? So the first issue that I want to pose here is basically, so where are we today? And it is no secret that in recent years, AI technology and robotics have reached new peaks. AI is getting better in providing services, improving public safety, creating new opportunities for businesses, and open the door for a better, accurate medical diagnosis, as we shared earlier. However, as Ian Carys stated, it's still considered narrow, performing individual tasks in well-defined and limited domains. We have not reached what scientists call singularity, which is a moment in time when the pace of technological change is so dramatic that human life will be irreversibly changed. The question is when we'll reach this threshold. And I just want to, briefly to share some thoughts about that, because I think this is one of the issues that is very interesting, and I think that all of us are very keen to know when. Vincent Muller and Nick Bostrom sought to answer this exact question. And Muller and Bostrom asked 550 experts when, if ever, they predict machine will reach the level of human intelligence. Over 50% responded that AI would reach overall human intelligence ability by 2040 or 2050, and over 90% that said that by 2075. 75% thought that AI would exceed human intelligence 30 years after reaching human level intelligence, and 10% expected that it would take only 3 years. However, as we probably understand, surveys are not science, and no expert can provide any substantial evidence for such forecasts. Going back to my preliminary question, I think the honest answer is that we can't say when, if ever, humanity will reach singularity. It might happen in 10 years or 50, or it might never happen. What we do know, however, is that with all the technological developments, Samantha is still only a very good movie, nothing more. And seriously, 90 ranking on Rotten Tomatoes, so it's a really good movie, so go watch. The second statement that I want to pose here is that there are no AI rights. No jurisdiction has yet recognized robots or computers' legal rights. There are calls for creating legal status for robots in the EU and the Saudi Arabia citizenship stunt, if you heard about that, but no country has seriously considered granting AI legal rights. Under no regime, AI is considered an author or an inventor. Human influence is still a minimal criterion for granting protection. Therefore, every non-human creation is either owned by a human agent or none. In practice, if we can establish human influence, as minimal or insignificant as it may be, the creation is left in the public domain for all to use and exploit freely. In the famous selfie monkey we all stated here, Dove and Maya, Naruto, the US District Court released Naruto's picture to the public domain, claiming that Mr. Slater, the photographer who placed the camera in front of Naruto, did not influence the creation, and well, since monkeys have no rights, no protection could and would be granted. So I just want to get into something that's more theoretical, and just bear with me. There are 3 stages of development when we look into mainly copyright and IP and computer science. So the first one is computer-assisted works. Second one is computer-generated works, and obviously what we all talked about, like AI works. In computer-assisted, the computer is no more than a pen, a tool, like Microsoft Word processor. Mr. Justice Whitford stated in the Express newspapers back in 1985 that it is unrealistic to argue that if you write your work with a pen, it is the pen which is the author. This decision reflects court's opinion in most cases and jurisdictions since then. But what happens when the human impact on the creative process is less dominant? Computer-generated works can vary between simple automated tasks that are pre-programmed to more independent systems. And with machine and deep learning capabilities, the software is free to find its creative way to solve the given problem, like the AI AlphaGo program that beat the top Chinese Go player in a move that no human predicted. The distinction between a computer-generated and computer-assisted work has recently argued in front of Alberta Court of Appeal. In the case of GSI, the court considered if collecting and processing seismic data automatically by a computer constitute a work protectable by copyright law. The court then established that the data was created with human input, and thus it is the case of a computer-assisted work that can be copyrightable. GSI, in my opinion, foreshadows a likely trend in computer-generated cases. Courts shuffling facts to find enough human ingenuity to establish human authorship within the computer-assisted work safe haven, so-called, even if there is strong evidence of minimal to zero human influence. The current debate around computer-generated works allows us to better understand the legal standing and neighborhood in which the idea of allocating copyright to a computer or AI creation has been developed. It seems that the legal community has not come to terms with the question of allocating rights to creation in which the connection between the author, programmer, and the work cannot be established, or it is too remote in time or function. Thinking about GSI, I've asked myself how I view future changes in IP law, if any. Is IP law is on the verge of so-called revolution, so what I'm thinking, or we can only expect minor changes or no changes at all. Looking back on the history of IP in the 19th, 20th centuries might favor the latter, meaning we should not expect many changes. However, I beg to differ. AI, in my opinion, is a game changer. Even if only half of the technological advancements will eventually fulfill, the IP law foundation would shake to its core. The very essence of IP has to be reevaluated. My suggestion might sound ridiculous, rights for computers, but think about that. 50 years ago, no one thought software should have IP rights, and 100 years ago, no one thought African Americans should have rights, no women should be allowed to vote. I'm not saying that AI and humans' legal rights should be the same. Obviously, there are differences. However, we ought to ask ourselves if copyright and patent law serve its original purpose to facilitate creation in an era when non-human create everything. I think that, take the copyright clause in the US Constitution, for example. The Constitution empowers Congress to promote the progress of science and useful art by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Do you think that monopolized authors' rights to AI creations serve this purpose? As Professor Michael Lemley expressed recently, the justification for copyright might not be sustainable in the future both for humans and non-humans alike. I find support for AI IP rights within the theoretical literature in IP as well. Under utilitarian, AI IP rights might be justified if by doing so, computer authorship is sufficiently incentivized to produce more innovation and intellectual output. Given the technological advancement in recent years, the need for human involvement is artificial. In fact, humans influence few inventions at all. Amending patent laws to recognize computers as patent eligible could motivate the scientific community to develop more machine learning programs that can create invention for the benefit of society without needlessly worrying about the human inventor criteria. I even found support for AI IP rights within the Lockean theory. True, the very essence of the Lockean theory is the person or the programmer rights to his fruits of his labor, meaning his AI creation. However, as the connection between the programmer and the AI's output distance, so increases the programmer unjust enrichment, as Locke described. Thus, even according to Locke, in my opinion, the programmer should not be allowed limited, should be allowed limited or none of the fruits of the AI's labor in the future. There are other Lockean justifications, for example, parent-child relations, which might reflect the AI-program relation. Locke emphasized the preservation of natural right, stating that parents' rights are limited by nature, and even a father has no dominion over the property or actions of his son. Those are only few examples, or two examples. There are more, which I would love to share with you later. So, to my arguments. So, I argue for a new standard for both AI and human creations. When it comes to AI, the classic author can be considered the programmer, the user, the AI itself, or joint authorship between either party. Alternatively, there may be no author at all if the AI work is in the public domain or if the AI is disqualified as a right bearer. Part of accepting AI-deserved copyright argument is a willingness to change the perception that only human creations are worthy of copyright protection. This perception derives from the romantic author and individualist paradigms and is rooted in our laws, in our copyright laws. For AI to be regarded as an author in law, it is essential to disconnect the authorship concept from assumptions about individualism and current perception of creation as a human monopoly. If we accept this argument, it is possible to move forward to establish a more reasonable balance between the author, any author, human or non-human, and the public domain. I'm willing to establish that an AI creation, given that it was created by an independent, intelligent AI, is the author of its creation. In the current stage of computer-assisted works, when the programmer is no more than a tool, the programmer reserves all the rights, moral rights and economic rights. The next stage, computer-generated work, is more complex. As indicated in recent cases, the courts will most likely prefer to establish a human impact on the creation, even minor, to avoid the difficult questions of AI rights. However, with the advancements of the technology, we might need to change the balance. In that case, I offer a joint ownership model in which part of the rights reserved to the programmer and part to the AI computer. Before you ask me, when I say a computer, I mean that the rights will either go to the public, become available for a short period of time, or a certain access in public libraries, etc., or the profit will be invested in government foundation or for other public causes. The only restriction will be the obligation to attribute the creation to the AI that created the work. As several scholars have pointed out, it is important to attribute computer AI rights for more than economic reasons. It is important to avoid potential exploitation of AI works, to promote the integrity of the knowledge, manipulation, integration, and degradation of works. This is a joint authorship model for computer-generated work. Obviously, we'll have to develop tests that will establish the human impact on the creation. The bigger the impact, the weaker the rights reserved for the AI. In the last stage, when and if we reach singularity, it is hard to predict what might happen. However, I suggest that we should not discriminate between human and non-human creations. In that regard, I advocate for AI legal rights, or at least a limited set of moral rights that will recognize the AI attachment to its creation. However, even in that scenario, the economic rights pose a serious challenge. We don't know what value, if any, financial gain will have on AI. On the other hand, as several scholars have suggested, humans might not value money in the future as well, like Star Trek and sort of. Or the cost of production will be so low that the price tag will be irrelevant. Think about the consumption of data today. We spoke about that earlier. Cheap and accessible, amateur creation, etc. So we don't know what might happen, but as stated earlier, that does not mean that we don't have the obligation to explore the possibilities. Thank you.
Okay, so the last one before lunch, before networking lunch. I'm going to talk about design of laws and respond to this question about how likely is it that we're going to need to change intellectual property laws to deal with AI. So AI and IP. So we're hearing a lot about intellectual property today, but I wanted to start with something else. There's a lot of discussion going on about how artificial intelligence is going to affect legal practice. You know, the robot lawyers are coming to take our jobs, and they're going to take the judges' jobs, and probably the young associates won't be too upset that they won't be doing discovery and due diligence so much anymore. And you'll be able to log on and get your robo-legal advice. There's a lot of discussion happening there. There's a bit less discussion happening about what I'm going to talk about. We've heard a lot today so far about all the different areas in which AI will be creative. And if you say that intellectual property laws reward creativity, and coming back to the topic of this panel, IP and commercialization, if the reason for intellectual property laws, and it's an if, is to motivate, incentivize, reward creativity, then there's a lot that AI will be doing that will be relevant. Pushing new frontiers in science, identifying patterns that can lead to new thoughts, putting new ideas together to come up with fresh new ideas, genomics, personalized medicines, radiology, chemistry, nuclear physics, all these things combined with AI, it's really exciting. The creativity is really exciting. And so the question then becomes, how does intellectual property deal with this? How does intellectual property respond when you have people or robots coming along and saying, I want the property in this. I want to be able to commercialize what I've done, what I've created, through the benefits that are given to me by intellectual property laws, monopoly benefits for the most part, to exclude other people from using what I've made, and therefore I get to profit. We already have difficulties around this question with respect to things like databases, as you've heard about, and there are discussions happening. So in Europe, for example, they've tried to implement database protective laws within the copyright framework. In other places, like Australia, databases are almost impossible to protect. You can protect what's in them, but protecting the database itself, very, very difficult under existing intellectual property laws. And as we move into a period where big data and AI are really changing the way we're looking at things like databases and the value of them and commercialization, then we start thinking, well, are our intellectual property laws fit for purpose? And so we look at copyright and designs and patents and trademarks, and the definition that the World Intellectual Property Organization gives was mentioned earlier. I actually think is a slightly misleading definition. I know they're the World Intellectual Property Organization and I'm just me, but I really am not very keen on their definition because it talks about property and ideas and the creativity being propertized, which is not exactly what intellectual property actually does, in my opinion. So I'm going to talk about what actually I think intellectual property does and how it's likely to respond to the changes that are happening in science and technology that we've been talking about. So 3 things. First, I suggest that if you look back over time, intellectual property laws have not changed very much, really, in response to previous industrial revolutions. If you say we're in the 4th industrial revolution, and I'll come back to that, then it'll be interesting to see whether really we see a revolution or an evolution of intellectual property laws. And so to look at this, I want to take you to metaphysics. I know that's a tough word just before lunch, but to look at the structure of intellectual property law and look at some historical trends and see what has happened in the past to try and get some idea of what might happen in the future. So the trends, where did we come from? Where are we now? And where are we likely to go? If we can identify some patterns in the information from the past and what's happening at present, then maybe we can see where we're likely to go if we leave everything unchanged, if we just let things rattle on without going in and saying we're going to make intentional changes to these laws. So a metaphysical approach focuses on what intellectual property law is, what it does, as opposed to what it's protecting. So a very brief summary of it. What is happening when you have intellectual property laws, well, the main intellectual property laws, copyright, trademarks, patents, design laws, kick in, is that you have something that's physical that exists out there. The law then creates a proxy for that, a legal proxy, and that becomes property, and rights attached to that property, and then you get to enforce your rights. And so there are 2 aspects here. There's the creation of the property, and then there are the rights that attach. A lot of the time you hear people talking about IPRs. They're talking about the rights. What can you do with the rights? A lot of what we're talking about here is the property. How do you create the property? What should be property? Who should get that property? Who should be allowed to create it and who should be allowed to own it, which are not necessarily the same thing. And so the operation of the legal system is underpinning all of this. And so it's the legal system that's determining what becomes property and what rights will then attach. And so when you heard talk about authorship from some of the previous speakers, what they're talking about is the creator. Who is the creator? Who is the person or thing that brings the property into existence that can then be dealt with? And under what conditions do they do so? So what I suggest is, and this is just a summary, but what I suggest is that the general gist of intellectual property is this. You have a creator. They come up with some novel, inventive, distinctive, original idea. They document it in a creative way, and they are rewarded with property. Rights then attach to that property, and through the whole force of the legal system, judges, police in some cases, and so on, you can enforce your rights over that property. And it's really important in this context, this is all territorially based. It's all within a particular jurisdiction. And in our world, we've got, well, it's a bit contested, but something like 195 different jurisdictions. If you want a patent, you've got to go and register in every single one you want to enforce it in. When you start looking at artificial intelligence, where are its geographical boundaries? Where are its territorial boundaries? They're melting. They're melting in front of us. And we've got these laws that were created a very long time ago, and we're trying to use them in this modern new world. So this is why we're seeing a lot of calls for change to the law, but I wonder whether that's really going to happen much. So looking back at the past, the Industrial Revolution era pictures, the original modern intellectual property laws, and I say modern as opposed to prehistorical intellectual property, which might be things like brands on cattle and that sort of thing, but intellectual property, copyright patents as we know them, started a very long time ago, 300, 600 years ago. And to some extent, those laws are very much what we're seeing today. So if you look at the example of the Statute of Monopolies, that was Britain's original modern patent law. Australia was a colony of Britain. It inherited its intellectual property laws. Today, as we speak, well, actually, they're probably asleep over there as we speak, but today in Australia, the wording of manner of manufacture, what is an invention that gets patented, comes directly, word for word, from the Statute of Monopolies, 1624. We are using laws created hundreds of years ago to try and decide about things like artificial intelligence and what should be patented and who should get to own it. And so you can see why there are calls for changes in the law. And similar things happen with copyright and trademarks and so on. What I suggest is the metaphysical structures that were put in place way back then are still in place now. And I would be quite surprised, I don't mind being wrong, but I would be quite surprised if we see very great changes as a response to artificial intelligence and the challenges it's throwing up. So if you look back through history, you've got these successive industrial revolutions. And I won't labour the point, but there have been very big changes in science and technology along the way. Alongside those, we've had very big changes in intellectual property laws. And so we've already seen reference to the US Constitution, but there were big, big changes in the way intellectual property was procedurally worked and the way in which it responded to these various technological changes was to tinker around the edges and say, oh, all right, we've got this new thing, gosh, we've got this new thing called a sound recording. How on earth do we deal with a sound recording? We create a new bit within copyright law, following the traditional concepts, but we create a new bit within copyright law to deal with it. The question is, what happens with artificial intelligence? Will we just create new bits around patents, copyright, trademarks, and so on? Or are we going to need to have a real revolution in the law to deal with these changes? So here we are in the present. You asked your grandparents or great-grandparents to look at these pictures, they'd say they're futuristic, they're science fiction, and to us it's just normal. And this is what's going to be going forward, but will the law be able to deal with it? So as you combine artificial intelligence with all of these other areas of scientific and technological development, and it would be a mistake to think artificial intelligence is the only thing that is challenging laws as we know them, intellectual property laws as we know them. The challenges are coming from all over, but artificial intelligence is quite a common thread running through. And as we see all these new technologies, we see challenges, and we come back to our list of what intellectual property's basic construction is, and we say, oh, we still have a creator documenting their ideas in an original way, getting property rights attaching, it being geographically bounded, and needing the law to enforce it. So you could say, well, the metaphysics haven't changed very much. Everything stayed remarkably stable, despite huge technological change happening around it. And just to give an example, just one example, and we're short on time, Sophia, the robot created by a Hong Kong company, has been given citizenship in Saudi Arabia. What might that mean for intellectual property? Well, for example, under Australian law, it doesn't recognise non-human created musical, artistic, literary or dramatic works. You have to have a human element, it's very clear. However, it does recognise works under international treaties that have been created by people, or perhaps things, we don't know yet, that are entitled to copyright elsewhere. If in Saudi Arabia or some other country that were to give citizenship to a robot, that robot would acquire intellectual property, in this case copyright, in what it's created, is Australia going to start recognising that and enforcing, even though its domestic law would say, well, no, we don't recognise that. We've heard about Ava getting recognised as a composer entitled to royalties. In Japan, there's a little, well, described as a 7-year-old chatty boy, except that it's not. There is no physical form to this robot. It's a bot who talks to people in the Shibuya ward in Tokyo. Mirai apparently means future in Japanese, and they've given this little bot residency of the city, or of the ward. So we are seeing the law adapting, perhaps. So the current state of IP, well, we're seeing amendments, we're seeing tinkering around the edges, we're seeing inbuilt principles like technological neutrality, which in principle means that the law should be able to adapt no matter what the technology is. We're seeing new treaties being made, we're seeing open source sharing economy and hearing a lot about it, although it's actually based on owning the underlying IP. We're seeing lots of change, but not much change to the underlying concepts. So to come to the end, the future, where are we going? Well, imagine if you could plug your brain into a computer and upload it all, or download. What does that mean for the idea-expression dichotomy in copyright that says you don't give copyright over ideas, you only give copyright over the way they're expressed? If your brain is now in a documented form, perhaps it doesn't work anymore. You have different examples in patents, in trademarks, where the technology is challenging the fundamental underlying metaphysical structures of intellectual property law. And so we don't know where it's going to go, but we do know that the challenges are dramatic. And what it might mean is that we have to either tinker with the concepts and say, all right, well, a creator, it can be non-human. We can have collaborative, communal ownership, things that we don't necessarily, in many jurisdictions, accept, and so on. We might have global courts, global jurisdictions. We might be able to tinker around the edges and overcome these challenges that are being put there. And I suppose the question I want to leave you with is, do we want to? If we don't, my prediction is things aren't going to change very much. The underlying concept will stay the same. We'll just see tinkering around the edges. This is what a lot of people would like, because if you look at the Googles, the Microsofts and so on, they've invested a huge amount, the pharmaceutical companies. They've invested so much under the rules of the current system. Not terribly keen on change, or dramatic change. But we must realise that if we don't institute dramatic change, things are likely to continue on. There are lots of people also who criticise the way it is, say it's artificial, arbitrary, not particularly fair and not particularly reflective of perhaps what the goals or purposes of copyright, trademarks, designs, patents are. And so leave you with this thought over lunch. If we do want to have revolutionary change, we better start talking about it very, very fast, because artificial intelligence is already upon us and the intellectual property laws haven't been changing. They've just been evolving gradually. And perhaps we've left it a bit too late to put those revolutionary changes in. And so lawmakers really do need to start talking about this, as well as things like how is it going to affect legal practice.
Okay, thank you everybody. We are running a little bit over time, but I think if we have an hour for our scheduled lunch, that should do us. And so what I want to do is take the remaining time before 12:30 to invite one or two questions from the audience before we move on. So if you have a burning question, even if you've been holding on to it all morning and you think your panelists here can help you, then please do. Raise your hand, and I think approach the microphone, is that right? We have to ask you as well to approach the microphone so that we can hear you online.
That people are scared of AI and they're scared for their own inventions and as opposed to open source. I see this going two ways. We can either all, gather, tighten our security and spend lots of resources on security and everything, or we can go open source. Maybe there should be each step of the way. The people working, bringing forth new innovation should be rewarded as they're going, not just the one past the post thing at the end there. I think that could be more doable with AI tracking each person's innovation. How do you feel about that?
If someone wants to answer the question, they can also maybe repeat the question for the benefit of those listening online, please.
I think your question is, can we look at a hybrid approach as opposed to a one-size-fits-all approach or an all-or-nothing approach? And I think absolutely. I think we see even in the traditional software domains that there is open-source software. Companies like Linux, for example, it's a tremendous system, enterprise-grade system that's available. And then we also see more proprietary systems. So I think absolutely you can take a hybrid approach, and there isn't necessarily a perfect answer. I think different communities will take a different approach to proprietariness or openness.
Thank you very much for the very interesting presentations. One question that came up in my mind relates to the key questions that might drive the decisions that we're going to make about intellectual property. And a number of the presenters talked about this question of whether, providing AI with rights is a good idea, because we have to decide whether that's going to incentivize AI to sort of create more innovation, and if it doesn't, maybe we don't want to give them rights. A sort of competing question that came to my mind is the sort of impact of giving AI rights or not giving AI rights based on whether it's going to increase or decrease inequality. And I mean, I think one of the things that we're seeing right now is the holders of IP, and we talked a little bit about, we touched briefly on this in the first panel, and questions around competition and things like this. Is the ability to hold IP one of the things that is driving the dramatic increase in inequality we're seeing around the world? And if, say, for instance, we give people who create artificial intelligences rights to financial rewards that are accrued or created by those AIs, is that going to create a super wealthy elite among the people who, own the rights to the creations of the AI, and might not having that occur be a reason for giving AI rights in and of themselves to the financial rewards that would accrue from their inventions?
I mean, thank you for the question. I think it's a very, very interesting and intriguing question. So I think to answer, because I think that the answer is depending on the model that we're going to adopt. Because you are right, it might create some anomalies, and it might create a super, you can also regard this AI creation as something that is very expensive, and most people will want to purchase it, and then the revenue from that creation is going very high. But on the other hand, it can also trigger something completely different. Like it can trigger that the human invention will become something that is elite, and then they will be more expensive. And I think that this is it's very important that when we establish the model, when we create the model for AI authorship, AI creation, we will get into that and explore these possibilities and these risks as well. However, if you look into the public domain model, it actually means that you share the rights from the creation to the public. So in my opinion, these risks are actually not that high or important. So yeah.
move on to the next? Or did you
I
want to?
was just going to add to that. I think it's really important to distinguish between whether we're saying AI gets personhood in itself, and in that case can attract all the rights itself, or AI is owned by somebody, maybe a corporation, maybe a natural person, and they accrue the rights. If we're talking about personhood, then we really have to start thinking even more dramatically about change because, for example, you think of the copyright term, life of the author plus 70 years. What's the life of an AI? And so you look at the patent term, if you go back far enough, it was decided, the length was based on how long was someone an apprentice a couple of hundred years ago and multiples of that. So you look at these structures that we're dealing with that are very entrenched, and you start applying them to a person, you give AI personhood and the ability to hold the rights, then you probably start needing to think about all these other things as well, and that affects the answer.
I just want to actually add one thing to that as well, which is, again, I guess this is a litigator's perspective, but it is how do you move against the entity that holds the rights? So in the example of co-ownership of rights, or if Sophia is to hold rights and you think Sophia has done something offside copyright law and you move against her, who's going to pay for that? And that is some really fundamental thinking about how do you create shared pools, if that's the case. Is there mandatory insurance in instances where AI will either attract personhood status or something close? So it really does attract issues of liability in a very fundamental way.
Okay, one more question.
Actually, my question kind of dovetails off your point. Spoiler alert for anyone who hasn't seen her. Samantha and the OS's leave, which begs a few questions, really around enforcement. So if you give an AI rights, how do we enforce anything against them? Do we use punitive code? I mean, we can't put them in jail. How do we show them as in contempt of court? And then the second corollary question is, in which jurisdictions are we even operating? Because we have 195 physical jurisdictions here. Do we liken it to aerospace law or maritime law? Do we have the jurisdiction of deep internet? I think it's an intriguing point to give AI some sort of right, but I'm very curious about your thoughts on enforcement.
I think we want to step back too and just maybe clarify when you say rights, you mean that you're recognizing them as a person, like, and then they're subject to the law like any other person, or are they given a property right, like copyright or something for the works that they create? And if we're looking at the first one, then I think that we need to look around maybe where they're operating, or where, like you see this jurisdiction cases that are coming up all the time. We're seeing how the Google and Equistack chase is being interpreted with this Craigslist case. I think if there's going to be doing business somewhere, if there's a commercial advantage, I think that's going to be a huge driver to what court may look to bring them into their jurisdiction. It's just a comment, but I'll let the rest of the panel jump in.
Yeah, I would also say it's not just if they hold the rights, it's the other side of it. Even if it's a natural person holding the rights in AI, what if another AI infringes? And then what if you can't trace, you have orphan works as it is, what if you can't trace who owns the AI or who's responsible for it? So there are all sorts of problems, and these are being looked at very much in relation to tort problems and self-driving cars and that sort of thing, but we haven't thought very much about them in intellectual property yet.
Can we move to the, oh, sorry.
I just want to say that we give legal personhood to a lot of non-humans, right? We give it to corporations, and we find people to blame and to ascribe blame in those instances. We can find people to blame for AIs. Whether or not that's fair to blame people for that is a separate question. But it's not hard to find someone down the chain to blame for a mistake or an action that an AI does.
Doesn't that go to the idea of the controlling mind, though? I mean, if AI has its own controlling mind,
There's an alternative that is being proposed, which is in certain instances of AI, and of course this is all context specific, but you would apply a strict liability system, meaning that and this is actually being explored mainly in the autonomous vehicle space. But what you do is you have a shared pool, some kind of insurance pool. And where there is something that has gone wrong, there's a strict liability system such that you don't have to prove fault. You just have to prove that something went wrong, or you just have to establish that something has gone wrong. And it's being explored very much in the context of AI for precisely some of the reasons you're raising, which is in certain instances, can you really is a fault-based system appropriate? Can you establish fault? Can I point to this person and say, well, it's actually your fault? We can do it by analogy, so you can use certain legal regimes that exist by analogy, but I think they're going to be stretched over time. I think that just remains to be seen.
So I think we're going to have time for one more quick question, if that's okay. Apologies to those of you who are waiting, and of course the conversation will continue over lunch, but yes, if you don't mind.
Thank you. I have a question about, which was touched upon on this panel and the previous panel as well, regarding the role of the large corporate players out there, you know, like specifically in the United States. I'm thinking IBM, Microsoft, you know, Google, who have been gathering arsenals of patents on this topic, on AI, big data, machine learning for the better part of a decade now. I mean, I think Watson was in 2011, it appeared in Jeopardy. In Canada, and I'm thinking, I would like to have your thoughts on what smaller jurisdictions like Canada, Israel, you know, Australia, Europe as well, what can be done in those jurisdictions to ensure that, you know, the power, you know, balance in terms of who controls the tools that will make AI sort of work isn't completely in the United States, isn't completely outside of Canada, for example, and that there actually can be innovation that proceeds in other jurisdictions. Is there any policy tools that can be done to promote, for example, patents development in places like Canada?
I think that we definitely are seeing huge players come in. I think antitrust law will come in potentially at some point, but looking at how can Canada develop a competitive advantage, I think we can look at alternative models like IP collectives, for example. Of course, those are only as good as the quality of patents that are in those collectives, and you also want to look at the objective of why do you want to be part of that pool. And I think touching on your point, if you're looking at big giants controlling, it probably is your freedom to operate. And so the benefit of having entities like that owning the patents is they actually are operating businesses as opposed to non-practicing entities. So I think if you are able to have even just a few really key patents on an area, they may be more open to negotiating and enabling that freedom to operate with you because they want to operate potentially that same improvement as well. So I think that is one model that we can look at.
And I'll just add very quickly that you got to look at your strategic advantage, right? We are a small nation. We have an advantage that we have been pioneering and leading in the area of deep learning for decades now, and that works to our advantage. Internationally, we are a recognized player in that respect. So Canada, from a bigger policy perspective, is just going to have to make some very keen decisions on where it wants to and how it wants to invest its time and money, and I think the government has done that with the announcement last year with funding going to a number of organizations for the purpose of creating a pan-Canadian AI strategy. So there will be some hard decisions, but for a starting point, we know that we've got some intellectual power. We know we're starting to attract some talent. And I think I was speaking to somebody earlier, I don't see him here now, but his point was, the government has a lot of data. Is there a way that can be leveraged to give our startups and our company a leg up? There are a whole bunch of legal issues there, but it's an interesting proposition.
Okay, well, thank you, everybody. But one of the concerns I had, or I'm just going to call it the anxieties I had about the panel and indeed the framing of what we would be talking about, thinking about IP and commercialization, was what I see often as an assumption that if or when we perceive gaps in the intellectual property system, that the legal proprietary structures that we have should be flowing in to fill those gaps and those interstices and to fill anything that's a result or that has value or as a result of investment with the weight of property. And I think we managed to some extent to avoid falling into that trap, although I noticed we were using words like shortcoming and fall into the public domain. And I think that that kind of terminology should make us think about the way in which the normative confines of our existing IP system are by design, and those limits exist for a reason. We ought not to be thinking about expanding them without revisiting the sort of normative justifications and rationales that explain the rights that we currently award. So perhaps as AI becomes more capable of creativity, one of the greatest things that it might give us, in fact, is the opportunity to free cultural, creative content from the confines of private ownership and to alleviate this need that we perceive to propertize in order to encourage creativity. And if so, that's a good news story for the public domain. So talking about unauthored works and the value of the public domain, I think any panel that features Naruto the monkey 5 times is a terrific panel. So please join me in thanking our panelists and enjoy your lunch.
Okay, now it's